into the children. Now, Lisa Harris had nothing to do with this case. But Lisa Harris was someone that Judge Gorcyca knew in the past had been pretty effective in terms of dealing with children, particularly when they were obstinate or reluctant to do what they were supposed to do. So she came up and she talked to the children. Nothing. Judge Gorcyca contacted a family counselor, someone who was working with the children by the name of Tracy Steve, who I anticipate will also be testifying. She tried to talk the children into going into the courtroom. Still nothing. The guardian ad litem, Bill Lancet, was there. He tried to talk the children into going into the courtroom, the jury room, and that didn't happen. Judge Gorcyca herself came out, told the children, please, I just need you to come into the jury room, as your lawyers have agreed, to spend some parenting time with your father. They refused as well. Now, ultimately, Tracy Steve, the woman that I had mentioned earlier, was able to finally get one of the children to actually come into the jury room, arguably to have parenting time with their father. And when that child came into the jury room, he sat down, put his forehead on the table, looked down, and did nothing else. Refused to have any meaningful participation with the father. And so ultimately, as Judge Gorcyca saw and observed, this didn't work. The prosecutor who was involved, Lisa Harris, urged Judge Gorcyca to have a contempt hearing right then and there. She said to Judge Gorcyca, understandably, this is ridiculous. These children are willfully disobeying your order. They are not meaningfully participating in parenting time, and they haven't. They haven't for years. And you ought to do something more serious and more severe. But she didn't do that. She decided that she was not going to hold a contempt hearing and not arguably find the children in contempt, but continue to try other efforts, other avenues to see whether or not she could get the children to comply. And she continued to do that for month after month after month. In November of 2014, specifically November the 12th, she received a very detailed report from the guardian ad litem, Bill Lancet, who I also anticipate is going to testify at this hearing. Mr. Lancet had been involved with these children for more than 4 years. And I fully anticipate what he's going to tell you is that the children's actions were ridiculous. They were out of control. They refused every and any attempt to have meaningful parenting time with the father. Bill Lancet, in his own report, called their behavior Manson-like, cult-like, and suggested that Judge Gorcyca needed to impose some type of draconian measure in order to get the children to comply. And Judge Gorcyca didn't do that, and she hadn't done that throughout this entire process. She tried all different kinds of ways and mechanisms, not only the meetings that I described, but other ways to get the children to comply. She took away their electronics. She limited their contact in terms of friends. She limited their extracurricular activities. Ultimately, she had them spend their spring vacation in her jury room. She tried anything and everything within her power to get the children to simply have parenting time with their father. And they refused time after time after time. And that's the context, Your Honor, of this June 24, 2015 hearing. And that's the context that I think the court needs to know and understand. So what happens on June the 24th? Well, once again, there was a proposal that the children meet in the jury room and have parenting time with their father.
I think it starts with your Exhibit 61, which is the day before the 23rd.
It does.
Which ordered that to occur on the 24th.
All right. You're correct, Your Honor. That's absolutely right. But it was that order that called for the parenting time in the jury room again on the 24th. And you're right, it was entered on the 23rd. I agree with that. And Judge Gorcyca was on the bench, and one of the children, I believe it was Rowie, was in the jury room. And as Judge Gorcyca got off the bench, handling other matters, one of her staff called her aside and said, "Judge, it's not going well. It's not going well at all in the jury room." She went into the jury room and found Rowie kind of theatrically sobbing with his head down, and again refusing to have any meaningful participation with the father. Judge Gorcyca rightfully said, "Rowie, sit up. Enough of this. We're not going to fool around anymore. We are going to have parenting time with your father." And eventually what she ends up doing is that she gets both of the parents, I believe the mother was there, father was on the phone, one of the lawyers was there, another was on the phone, and talks to them on the phone about her idea in terms of moving forward. And her idea was that she was going to write out a statement for the mom. Mom hadn't taken charge at all up to this point in time, but a statement that would tell the children in no uncertain terms that your father loves you, I want you to have a relationship with your father, I want you to meaningfully participate in parenting time. And she did that. She ran that statement by the mother, the father, and both of the lawyers, and they all agreed. Mother then, I suppose to her credit, actually reads the statement to Rowie. And after she does that, the question is posed, well, are you now going to have parenting time with your father? And the answer is no, I'm not. So what Judge Gorcyca decided to do at that point was, because enough was enough, to appoint lawyers for each of the children and to hold a contempt hearing. That was absolutely not her first choice. What she was hoping that would happen, particularly with her personal intervention and writing out a statement for mom to read, is that the children would finally get the right direction and do exactly what they were supposed to do, but they had refused. And so lawyers were appointed for each of the children, and these are lawyers who are not only highly skilled but highly experienced. I think each of the lawyers, you'll come to learn, has spent more than 30 years in practice. They each met with their client, and presumably based upon the videotape that I've seen, each of them urged their client to comply with the court's order, urged their client to simply have parenting time with their father. And as you'll see from the videotape, ultimately, none of them chose to do that. And Judge Gorcyca was presenting the children with a very clear choice, a very clear alternative that they themselves chose. What she wanted to have happen was for the children to choose the sane, reasonable option. Just have parenting time. Go to lunch with your father, please. Because if you don't, there are going to be consequences. I've tried all of these other things with you. This has gone on for year after year after year. You're not complying, but you don't run the show. Please, just have parenting time with your father, or here are the consequences. And she was pretty stark. She was pretty direct, and she was pretty straightforward, because she was trying, understandably, to send a message. And the message is, children, you don't want this. You don't want to choose going to Children's Village. Please don't pick that option. But they did. And I know that the examiner and co-examiner have complained, at least in the past, about the fact that the children were actually handcuffed and led from the courtroom. And certainly that wasn't a pretty picture. But you'll hear from Deputy Maloney of the Oakland County Sheriff's Department, who was there and present, that Judge Gorcyca had nothing to do with that. She is not in charge of security. She's not in charge of the Oakland County Sheriff's Department. She does not control how the security is handled in her courtroom. And so that was strictly a decision made by the Sheriff's Department. But the decision to go to Children's Village was a decision made by the children themselves. And again, I anticipate you're going to hear from each of the lawyers who were appointed to represent the children. And unless I'm mistaken, not one of them filed a motion for reconsideration of Judge Gorcyca's decision. Not one of them filed an appeal or an interlocutory appeal as to Judge Gorcyca's decision. Not one of them filed a writ of mandamus, a petition for writ of habeas corpus, or, to the best of my knowledge, filed any complaint with the Judicial Tenure Commission. Not one. Now, the second count of the complaint deals with a couple of alleged misrepresentations by Judge Gorcyca. One has to do with this whole idea of holding the children in contempt because they refused to go to lunch with their father. Well, again, that's not true. She denied that in her answer, and appropriately so. Because what Judge Gorcyca tried to do was to try to get the children to obey her order. She was not punishing them for not agreeing to go to lunch. She was trying to encourage them, coerce them, if you would, into obeying her order. Her order involving parenting time, which happened to be occurring over the lunch period. That's not a misrepresentation. The other alleged misrepresentation has to do with the hand gesture that Judge Gorcyca made during the course of this June 24th proceeding, where she has her finger or hands up by her temple in a swirling motion, arguably suggesting that she thought the one child, Liam, was somehow crazy. Judge Gorcyca then and now has no real memory of doing that, and I think she'll tell you when she went back and looked at the videotape, she was quite surprised to see that gesture. She's not the kind of person, and isn't the kind of person that puts labels on people, uses hand gestures of any sort, and certainly hasn't used this type of hand gesture in the past. Now, I will tell you and I will acknowledge that as you look at the video, it looks like that type of hand gesture. But what she said in her 28-day letter response, what she said in her answer, was that's not what I intended to be. It's not the message that I intended to communicate. And to the extent that anyone took it in that way, then I apologize and I'm sorry. I take responsibility for that. But that is not what I intended or meant it to be. Period. And that is not a misrepresentation by any stretch of the imagination. Judge, this is an important case, certainly for Judge Gorcyca, but it's an important case in a broader sense, because it's important that there be a context to a judge's actions. The court rules speak to that. Specifically, 9.205 talks about misconduct, persistent judicial incompetence, persistent lack of respect, cordiality, dignity afforded to litigants and to the parties. That's not what we have here. And I respectfully submit that if the court were to decide in favor of the examiner, you'd be sending a very clear message, but the wrong message. And it would be a message of, don't make the hard decisions, don't make tough rulings, and for heaven's sake, don't try to enforce your orders. orders that you had been attempting to obtain compliance with for 5.5 years. That's a very dangerous message to send, Your Honor. Your Honor, I'm convinced that at the end of this case, when you hear all of the evidence, and you see all of the evidence put into its proper perspective and context, you will make the only recommendation that you can to the Commission, and that is there's no judicial misconduct here. Thank you.
All right, first witness for the examiner.
Your Honor, the examiner would move for the admission of examiner's proposed exhibit, I believe it's number 13, I'm sorry. (139).
That would be the register of actions.
No, 139, Your Honor, is a DVD of the hearing from June 24th, 2015.
Sorry. No objection, Your Honor.
Exhibit 139.
And, Your Honor, I do have it up on the screen, visible in the courtroom. There's another screen on your bench. That video is composed of 3 portions. I will play each of them back to back.
All right, go ahead.
Good morning, good afternoon.
Good afternoon, Your Honor. My name is Jeffrey Schwartz. I've been called to the courtroom to represent Liam Tassoni. It's my understanding that the court is on the verge of holding him to contempt. I had a long discussion with him. I explained that he has basically 2 choices, that he could apologize to the judge for not following orders and communicate with his father and submit to supervised visits, or the court's intention was that he's going to be held in contempt and he's going to be placed in Children's Village until he complies. So I'll let him speak for himself and indicate to the court what his intention is.
All right, so what is your name for the record? Well, what do you want to say to the court, if anything?
Okay, so I do apologize if I didn't understand that the rules of with apologize to whatever I did to you, but I do not apologize for not talking to him because I have a reason for that, and that's because he's violent, and I saw him hit my mom, and I'm not going to talk to him.
All right, well, the court finds you in direct contempt. I ordered you to have a healthy relationship with your father. I witnessed your mother at 11:30 tell you very impassionedly that she wants you to talk to your dad, that he loves you, that he's not going to hurt you, that he's not going to hurt her. You are a defiant, contemptuous young man, and I'm ordering you to spend the rest of the summer, and we'll review it when school starts, and you may be going to school there. So you're going to be, I'm ordering you to Children's Village. Is there anything you'd like to say about that?
I didn't do anything wrong, so...
No, you did. I ordered you to talk to your father. You chose not to talk to your father. You defied a direct court order. It's direct contempt, so I'm finding you guilty of civil contempt.
Then he was ordered something wrong.
Pardon?
How come... I thought there was like rules for like not hitting someone. Why am I going to?
I ordered you, I will say this again, and apparently you're supposed to have a high IQ, which I'm doubting right now, because of the way you act. You're very defiant. You have no manners. I ordered you to have a relationship with your dad. I ordered you to talk to your father. Your mom told you to talk to your father. There is no reason why you do not have a relationship with your father. Your father has never been charged with anything. Your father has never been convicted of anything. Your father doesn't have a personal protection order against him. Your father is well-liked and loved by the community, his co-workers, his family, his colleagues. You, young man, have got it wrong. I think your father is a great man who has gone through hoops for you to have a relationship with you. You are in contempt, and you are going to live in Children's Village. Remind me how old you are?
15.
You may stay in there until you graduate from high school.
Judge, just for the record, I'd like to make clear that my client mother did comply with the court's directives. The court asked mother to speak with the children about the necessity of the relationship with their father, and I believe she did so to the court's satisfaction. So as far as that I think goes, I just want to put that on.
And that was very well said, Mother. I appreciate that you did say that. It may have been way too late. It probably was way too late. Your children, you need to do a research program on Charlie Manson and the cult that he has. Your behavior in the hall with me months ago, your behavior in this courtroom, your behavior back there, is unlike any I've ever seen in 46,000 cases. You, young man, are the worst one. So you have brought yourself living in Children's Village, going to the bathroom in public, maybe summer school, I don't know, but you and Mom, the only person allowed on his, well, according to me, you're not allowed to visit him. It's only your father and any therapist and anyone your dad chooses to bring in, and your attorney. Mr. Schwartz, I appreciate you accepting the court's appointment. You are an excellent lawyer. I know you did your best, just like you would try to do in every case. You had very simple choices, and you're clearly very messed up.
Just for the record, I'd like to place an objection that Mom would like to visit the child to the extent approved by Children's Village. She did comply with the court today, and I know that it's very important for her to maintain as much contact with her son as permissible by both the court and the village.
All right, I accept your objection for the record.
Just for the record, I do have a sentence set for 1:15.
You are ready. We're done.
I was just going to indicate to the court I'm going to be in Judge Potts at 1:15. I'm going to be in Referee Racy at 1:30. I'll be in the building until about 2:30 if anything changes.
Okay, so I'm sentencing you to Children's Village, I guess Mandy's place, pending you following the court's direct order. When you can follow the court's direct order and have a normal, healthy relationship with your father, I would review this. I mean, it might be one day, it might be 3 years, it might be till you're 18. This is over your dad's objection. I want this to be heard. Obviously, it's over your mother's objection. Your dad, I wanted to do this because of your horrific behavior long time ago, and your dad begged me not to. He begged me not to. So it was only because your dad, I would have switched custody and they would have appealed because I find it's you are so mentally messed up right now, and it's not because you're a father. And one day, you are going to realize what's going on in this case, and you're going to apologize to your dad. So that's my order. We'll set a review hearing, I guess, September 1st. Unless you, for whatever reason, talk to your dad, and your dad comes to me and says, oh my gosh, and he's at counseling at Children's Village. And your dad says, Judge Gorcyca, my son has seen the light and he's changed, and can you let him out? And he wants to have a relationship with me, and then I'll do it. So Dad, just let us know when that happens. And if it doesn't happen, actually, you know what? We're just going to set a review hearing when you're 18. Dad, if you ever think that he has changed and therapy has helped him and he's no longer like Charlie Manson's cult, then you let us know and we can do it.
Judge, may my client speak or say some words to Liam before it's taken off?
There's nothing but what she said, no.
Just possibly a goodbye, talk to your dad, that type of thing.
She's already done that. He's a defiant child. You're a child and you're defiant.
May she try more time in the court. I think Liam is maybe a little bit more appreciative of all the pressure that is being put on him right now. No. It may be worthwhile to do it.
I have said this to you over and over and over again. This deputy right here, Deputy Maloney, has been amazing at trying to help you. He tried you again today. He tried last couple months ago. My family counselor, nothing's getting through to you. So you're
All set, Your Honor?
Yeah, we're all set.
Thank you, Your Honor.
Thank you for paying for work.
May I approach you?
Yes, it's me.
My client wants to know how long you have to talk to the mother. Read the roll. I said I wasn't sure.
All right, Andrew, could you approach?
Yes, Judge.
Yeah, approach. And Andrew will tell you, Rory would like to talk to his dad, so we're going to see how that goes before we have that one. Miss Tracy Racy, would you go back? You on your lunch hour? Thank you. We're waiting for someone for.
She's already getting back. I'm sorry. Oh, okay. Natalie, your attorney is here.
Let's just say review in September. This is day for liberty. Use inject civil contempt sentence to Children's Village Mandy's Place review September 8th, 9 a.m. That work? Is that good, Debbie? There's two other little kids that are very well going to. Yeah. Yes. Be lovely.
Proposal number 4 on the docket. Court recalls Simone versus Simone, case number 097667490M.
Your Honor, Karen Cooper is just appointed as attorney for Natalie.
Is Mom here? Dad's here. Is Mom's attorney here? All right. Good afternoon. Thank you for accepting the court appointment.
Oh, thank you. Your Honor, I've had an opportunity to talk to Natalie and told her the consequences of not being respectful to the court and to court orders, and told her what Children's Village was like, which I have very good acquaintance with, and told her my best legal advice would be for her to apologize for whatever she did. I don't have a complete narrative on everything she's done, and she's absolutely refusing to cooperate even with me.
Oh, it's so interesting. So interesting. Where is Mom here and Mom's attorney?
They're coming right now.
Okay.
Can you just put the order on that I just be able to see them?
Oh, yes. Okay, and the other one. Can you add that one, okay?
I did tell Mr. Dean to come in with Roy.
All right, we're oh.
I appreciate this. On behalf of Roy right here. Stand right next to me.
All right, will you state your name?
Thank you, Your Honor. Good afternoon. Michael Dean, P32631, appointed to represent Roe Tapani in the matter here before Your Honor. I appreciate on behalf of my client all the time that you've given me to talk with my client about the action that you're looking for and the possible consequences. I've apprised him of what he needs to do today before Your Honor, and basically he's going to tell you right now. I have no idea.
Okay. Sir, since you're older, wait, you're older, right?
Yes.
Just the middle.
What's your name, sir? How old are you? What's your name, ma'am? How old are you? All right. All right, what do you want to say, Roy?
I'm sorry for my behavior. Dad, I'm sorry for my behavior.
Look in his eyes, I told you, never to look.
Dad, the judge wanted me to talk to you, so here is something about myself. I'm doing something, I talk to you and talk with you.
And what do you hope, do you mind, Your Honor? What is the thing that you're going to talk about? What do you going to tell the judge that you're going to be doing from this point forward when you get together with your dad? What was the C word we talked about? Communicate. That means dialogue, back and forth. Remember I told you not to be just a stick in the mud. Your dad asks you a question, you respond. That's how one develops a relationship, starting through communication. Are you in agreement with starting to communicate with your father so that you can build a relationship?
Yes.
Look at your father's eyes and say that. Look at the judge's eyes and say that.
Let me hold off with you. What do you want to say, Natalie?
Just asking her now that her brother's apologized, if she would reconsider. Would you like to apologize now that your brother has?
All right, I'm taking that as a no. All right, Natalie doesn't want to say anything.
Apologize. I was trying to get her to reconsider.
No, you're so sweet, but obviously, no, Natalie, don't read what your brother wrote. You're your own person. You know what? I know you're kind of religious. God gave you a brain. He expects you to use it. You have a brain. You are not your brother. You are not your big, defiant brother who's living in jail. Do you want to live in jail? Just tell me this right now.
You want to go to jail?
Mom, you must step away.
Step away. There you go.
I'm urging you to apologize and say you'll go and work with your father in the business. Can you do that?
I'm sorry. I'm trying to work with my father at visits.
Well, you're going to stay here all day, and it's going to be up to your dad. I'm going to see how you two act. Maybe the three of you should go to lunch in the cafeteria. If you have any hesitation now, you're living in Children's Village. You're living in Children's Village. You know what that would do to your mother? Going home, riding down the elevator without you? Can you guys think about someone besides yourself? You should be thinking about your father and what your father has gone through unnecessarily because of I don't know why. And it's despicable of me what your father has gone through when he loves you and he wants to be in your life. He wants you to be in his life. I'm so upset with you. I'm so upset with you. I'm even more upset with your brother. And I won't say what I think about your mother. I think your mom did something nice in the jury room for once. And I like your dad. And you haven't used your judge for 5.5 years. How old will you be, Natalie? Let's see. You're going to be a teenager. You want to have your birthdays in Children's Village? Do you like going to the bathroom in front of people?
She said no, thank you.
Is your bed soft and comfortable at home?
Yes.
You need to
The point is this. You two don't have a nice lunch with your dad and make this up to your dad. You're going to come back here at 1:30 and I'm having the deputies take you to Children's Village. So, Ms. Tracy Steed, Mr. Lance, see him here. Who do you suggest have Mr. Art?
Mr. Gallagher, we can come, I think he can go with those two.
Dad, what do you think? What is your suggestion, Dad? And I want you to know, I wanted to do this to you all many times. Your dad said, don't, Judge Gorcyca. Please don't do this, Judge Gorcyca. It was because of your dad that I didn't do it. Your mom didn't want me to either. But the ball was in your dad's court. Your dad is in charge. Unless you want to live in Children's Village. It's up to you. I have put other children in Children's Village. You guys can all hang out together. Dad, what do you suggest for lunch? Everything is recorded. I'm going to watch. You walk, the minute you pull into this courthouse, you're videoed. Outside, they can get you walking in, they can get you everywhere except in the bathroom.
I'll go with my brother.
Pardon?
I'll go with my brother.
What does that mean?
Children's Village?
So you don't want to have to turn each other's brother?
Do they realize that they would not be seeing their siblings?
You're not even going to be your brother. That's cool. You'll be the same stuff. Up put it there, stay away from your brother. All right, so you're admitting you won't have parenting time with your dad. Okay, is that a yes?
Yes,
Okay, court finds.
now she's refusing because her brother is.
I'm not refusing because my brother is.
Why are you
I'm
refusing?
refusing because I want to refuse.
It's ridiculous. I have to say,
I told her.
I've never seen anything like this. One day you can watch this video and realize that you two have been brainwashed. Your dad is a good man. Your dad is a good man who loves you. You have been brainwashed. You are brainwashed. This is not normal behavior. No adult in this courtroom, except one, thinks this is normal. Every single adult in this courtroom thinks you have been brainwashed. Your dad is a good man. Wipe that smirk off your face, Rowie. I don't know what that is. I've never seen anything like it. You're a defiant, contemptuous young man. The court finds both of you in direct contempt. You both are going to live in Children's Village. Your mother is not allowed to visit. No one on your mom's side is allowed to visit. Only your father and therapist and Mr. Lancet. When you are ready to have lunch with your dad, to have dinner with your dad, to be normal human beings, I will review this when your dad tells me you're ready. Otherwise, you are living in Children's Village till you graduate from high school. That's the order of the court. Goodbye.
Will I be released or?
Yes, thank you.
Okay, thank you, Your Honor.
Court appreciate.
I apologize for not getting any further.
I need to run the other one. No one from outside is allowed to visit.
No, she's not just today.
Okay.
Judge, will the court be appointing attorneys for the children longer term for their review hearing dates?
Yes, I'll keep the attorneys. I'm going to keep the attorneys for the review date, which will be September 8th at 9, unless, Dad, you come earlier, because you're going to be on the approved list with Mr. Lancet. When the children say they're ready to have a relationship with you, I will. When you're ready to come in, I'll do it that day. We can do it next party. However, maybe not next party, but
So the attorneys are staying on?
Yes, is that okay?
And we get a copy of the order. I get a copy of the order then.
We'll get in touch.
Yes, I don't have this.
I'm going to the mom. I'm Andy. We haven't got a chance to meet. Bossary.
Okay.
I'll get in touch.
Okay. Okay, I'm sorry. Yeah, I just got some new papers.
Maybe the transition of the copy website.
Oh, yeah, sure.
Is it 139?
Correct, Your Honor. And corresponding to that exhibit is the transcript, which is exhibit, I believe, 152. I would move for its admission as well.
Okay.
Examiner will call to the stand Judge Gorcyca.
Once you're situated, you may proceed.
Thank you. Judge Gorcyca, how long have you been a judge?
7.5 years.
And prior to that, you were employed by the Oakland County Prosecutor's Office?
Yes.
And how long was that for?
About 16.5 years.
Were you assigned to any particular division for majority of that time?
Yes.
Which one was that?
Domestic violence and elder abuse unit.
How long have you been an attorney?
23 years.
And during your experience as an attorney, have you handled cases involving juveniles?
Yes.
Few or many?
Many.
I'm sorry?
Many.
As a judge at the Oakland County Circuit Court, you had a chance to come in contact with the Simone versus Simone case, correct?
Yes.
And the case number is 2009-766749. Does that sound familiar?
DM at the end?
And DM stands for divorce, correct?
Yes.
With children.
the child.
Let me show you what has been marked as examiner's proposed exhibit number 22. Is there a number in the top right-hand corner?
Yes.
And is it the number I just recited?
It might be. Yes.
I'm sorry, it might be or yes?
09766-749 DM.
Okay, thank you.
Exhibit 22 is an order dated July 24th.
Yes, Your Honor.
July 24, 2014?
13. Now, the first numbers in the case number signify when that case was filed, do they not?
Yes.
So this case would have been filed in 2009.
Yes.
There were 3 children in this case, correct?
Yes.
And just for the record, and also, rather than using the children's names, we're going to use initials, okay? So that the oldest child would be LT. Can you follow that?
Yes.
And the middle child we'll call RT, and the youngest NT. And at times I'll refer to them by ages, and there would be ages in 2015 as of June 24th, 2015. Can you follow me?
Yes.
Okay. The judgment of divorce was entered in 2011, was it not?
Yes.
And in fact, it was signed by Judge McDonald, correct?
No.
I'm sorry, who was it signed by?
I thought you said assigned by.
No.
Yes, it was signed by retired Judge Jack McDonald.
Okay. Let me hand you what has been marked as examiner's proposed exhibit number 2. And for the record, what did I hand you?
The judgment of divorce.
And is that the judgment of divorce in the Simone versus Simone case?
Yes.
Move to admit?
No objection?
No objection.
Admitted. Were you using Exhibit 22, Ms. Rainier, to refresh the judge's recollection?
For the time being, yes, Your Honor. I will move for its admission later on as we go into that area. Judge Gorcyca, in 2010, specifically August 25th of 2010, you appointed a GAL.
Yes.
And GAL stands for Guardian Ad Litem, does it not?
Yes.
And do you recall why you appointed a GAL?
There were issues between parenting time and mother requested it.
And when you say issues regarding parenting time, it is correct, is it not, that the father in the divorce resided in the state of Israel up until 2015, did he not?
Yes.
And in fact, he visited roughly 3 or 4 times a year, did he not?
I don't know how often he visited.
When you say there were issues when he would come to the States, the United States, for visits, correct?
Yes.
In 2013, You issued this order. I would move for its admission at this point, Your Honor. That would be Examiner's Proposed Exhibit 22. You issued an order. Let me hand you that order again. Can you look at the top of page 2? That is an order in the Simone versus Simone case, is it not?
Yes.
You issued that on July 24, 2013.
Any objection, counsel, to its admission? Be admitted.
I'm sorry. Would you like me to repeat the question?
I answered your question.
And your answer is yes?
Yes.
On top of page 2, you state that, and I'm sorry, starting on page 1, if either party fails to comply with this court's orders, they will be subject to the contempt powers of this court and be detained for 20 days for the first violation and 40 days for a subsequent violation. You see that?
I do.
And in fact, that was addressed to the parties.
Correct.
Who are the parties?
Mom and Dad.
And were Mom and Dad before you, if you recall, on that date?
Well, it was a stipulated order, and it's signed by their attorneys. And we could play the video, and I could see if they were there.
Okay, but certainly their attorneys were there.
Yes.
And this was meant to address the parties, correct?
Clearly.
Up until June 24th, 2014, I'm sorry, 15, may I? Were the 3 children ever brought before you in your court on the record?
No.
On June 23rd, 2015, there was a hearing, was there not?
Yes.
And in fact, there is a video of that, correct?
There's always a video of any court hearings.
Okay. Did you have a chance to review the video of the June 23rd, 2015 hearing?
Yes.
And I'm assuming you have no issues with its accuracy?
No, I don't have any issues with any video's accuracy.
How about the transcript?
There might be a couple issues with the transcript.
You want to move? I would move for the admission of Exhibit 138 as well as Exhibit 10. The authenticity had been stipulated to us to both. I would move for their admission.
Exhibit 10.
10 is the transcript, and 138 is the DVD of June 23rd, 2015.
Okay.
Would be exhibits 10 and 138 would be admitted. I believe, having reviewed all of the exhibits this past weekend for both sides, there's a lot of redundancy. I think...
And Your Honor, it's my understanding that their exhibits that they're entering today were all prefaced with an E, while our exhibits were prefaced with an R for respondent.
Right.
So I don't know how we want to handle that.
Yeah, I believe, for example, the DVD, well, we can go through the exhibit list later on off the record and potentially admit those duplicative exhibits that were respondents as well, but proceed to
Judge Gorcyca, let me hand you what has been marked as examiner's now admitted Exhibit 41. If I did not move for its admission, I would move for the admission of proposed Exhibit 41.
Swear, what is that?
The June 23rd, 2015 order.
All right, no objection.
and that's, I believe, for example, that would be Defendant's Exhibit 61. So Exhibit 41 is the same as Respondent's Exhibit 61. That'll be admitted.
That is the order, Judge Gorcyca, that you issued on June 23rd, 2015, correct?
Another stipulated order.
Okay. But you signed it, correct?
I did.
And starting on the bottom of page 1, which is Bates stamp 426, it specifically provides for visitation to take place on June 24th, does it not?
Yes.
Reading from that, quote, defendant shall exercise parenting time on 6/24/2015 in the jury room with, Your Honor, if I may, I will abbreviate the name to maintain confidentiality with children, with RT, continuing, from 9 to 11, comma, lunch with NT and RT from 11 to 12, and with NT from 12 to 2. Did I read it correctly?
You read that part correctly.
There is another provision for father's additional parenting time starting on July 14th, does it not?
Yes.
Does this order mention the 13-year-old LT with respect to June 24th, 2015 parenting time?
It does not, but it does on July 14th as well as July 17th.
Okay, but that's not my question. With respect to June 24th, was the 13-year-old to even appear for parenting time?
According to this order, no, but Mom brought him.
Okay. According to your order that you signed, right. No.
But his parent brought him.
Can you answer my question, yes or no?
I did.
Is your answer yes, that it does not cover LT, the 13-year-old child, with respect to June 24th?
For the second time, yes.
Now, on June 23rd, 2015, you also gave some warnings to the mom, did you not, Judge?
Yes.
Let me hand you what has been marked as now admitted examiners Exhibit 10. That is a transcript, is it not, Judge?
Yes.
Can you turn to page 15?
Yes.
Starting on line 12, you're addressing the mother, do you not, at that point?
Yes.
And you tell her, quote, I've been telling this to you for years. If this doesn't improve and if the show cause goes forward, you are going to be strip searched. You are going to take off your clothes, squat, and be strip searched. You almost were the last time, but for him. Who were you talking about when you said him?
Dad.
Okay. And quite frankly...
You know about the time when she was supposed to turn herself into detention and they were going to take her across the street and that's what was going to happen.
Can you just follow my questions, Judge?
You're taking that out of context completely.
Okay. And let's continue. And I'm reading. And quite frankly, but for her agreeing. Who are you referring to when you say her?
His attorney. Because before that happened, Ms. Marnier, you cannot take one line out of anything and expect it to have its full meaning.
Your Honor, may I have the court's assistance? My questions are simple. Who are you referring to? Can this witness answer the questions as they are posed?
Your Honor, I think
the witness can and has, but she's not going to testify to things taken out of context. And I think she has the right to indicate that.
Mr. Kramer, I've read the entire proceeding. Judge Gorcyca, I've read all of your exhibits. Coming in, I've always been prepared to debate. I understand the situation, the context that led up to the 23rd and the show cause hearings and potential contempt hearings as it relates to the mother. I understand in which context it's being taken. Mr. Kramer, you will be allowed an opportunity, as we discussed on Friday, instead of crossing the witness, your opportunity to do a direct will be reserved later on, and you're free to examine or explore any of the matters if you wish to in further detail. To put them in context for the record, although the master has read the exhibits and does understand, I've gone all the way back to Judge Gorcyca in 2009, so I've read everything. So I understand what you were referring to on the 23rd as far as reference back to earlier proceedings and motions, the multiple motions that have been filed in this matter.
Sorry, thank you. I appreciate that.
Just answer Ms. Rainier's question. Go ahead.
Let's try this again. You were referring to Dad's attorney when you say her, correct?
Yes.
And who is Dad's attorney? Or who was?
That attorney was Dad's second lawyer, Carrie Milditch.
And then you continue saying, quote, they made extraordinary accommodations for you, and it's not working. When you say you, you're talking about the mother, correct? The plaintiff. Correct?
Yes.
So let's go to 624. By the way, were the 3 children before you in court on a record on June 23rd, 2015?
No. I don't think Mom brought them that day.
Did you ask for them to be brought so they can appear before you on that day?
Did I ask for that? No.
Yes. June 24th, 2015. That fell on a Wednesday, did it not?
Yes.
And Wednesday in Oakland County is motion day.
Yes.
Do you remember whether you had a docket on that day, other than the Simone parenting time in your jury room?
I had a very busy docket that day.
Now, from the order that we just had admitted, parenting time for RT was to begin at 9 o'clock, correct?
Yes.
And you have no information that Mom did not bring those 2 children to court as scheduled. Am I right?
That's not correct. Mom brought them in late.
I'm sorry?
She was late.
And how late?
I would have to be guessing and say 15 minutes.
I'm sorry?
I would be guessing to say 15 minutes.
50 or 15?
15.
Okay. Did you see the mom come in, or did someone tell you that she was late?
I saw her come in.
Okay. Did she come into the courtroom with the children?
She came in the courtroom. I remember her in the courtroom with the older son. I don't recall if the other 2 were with her at that time. I don't know. I can't be sure.
Okay.
But I specifically remember Mom and at least one of the children coming into the courtroom during my busy morning.
At some point in time, you received information that parenting time was not going well, correct?
Yes.
Who gave you that information?
My secretary, Ann O'Brien.
Now, where was this parenting time to take place?
Right in my jury room.
Is your jury room across the hallway from your courtroom, or is it right in the
Thank you.
back of the courtroom?
It's right there. It's right next to my chambers. So you walk out the private door and it was basically there.
Okay. Is there access to your juror room without having to walk through your courtroom?
Yes. But it's not for everyone. It's private. You'd have to buzz back to get in.
To your knowledge, where was your secretary? I'm sorry, you said Ann O'Brien?
Well, she's now Ann Atchison, but at that point she was Ann O'Brien.
Okay. So, where was Miss Atchison when she made these observations as to how well or not well the parenting time was going?
I would only be guessing that she either went in and looked herself or someone told her.
Did you talk to anyone else at that point?
No, at that point, I don't think I did.
At some point, did you go into the jury room?
Well, before I went in the jury room, I would have had to talk to Tracy Ray Steeb.
And who is Tracy Ray Steeb?
She's the family counselor assigned to this case.
Was she in your courtroom, or did you have to summon her?
Nope, she was there. She is always there on Wednesday mornings to assist.
Did you have some conversation with her?
Yes, I did. It would basically have, would she want to come in and help?
Come in and help whom?
Parenting time, the family.
And where was Miss Atchison during that time when you're having this conversation with Miss Steeb?
Oh, she wouldn't have been, I don't recall her even being around. We were short-staffed that day. She was basically running in the back with another person. So I don't think she would have been part of it. That was not her role. Her role was, she was my secretary.
When you go inside your jury room, who else goes with you?
Tracy Ray Steeb.
And not Miss Atchison?
No, not that I recall. Not that I recall at all of her going in.
When you enter that room, who is inside?
I remember Dad, the middle child, RT.
Thank you.
And Art Gallagher, the parenting time supervisor. And I don't think Mr. Lancet was in there at that time. I know he was in there at other times, but I don't know for sure if he was in there at that time.
And you mentioned Art Gallagher, correct?
Yes.
Parenting time supervisor.
Yes.
Who was he and why was he in the case?
He was in the case to supervise visitations, to report back, to help, to facilitate. He'd been on it for about 2 years.
And there had been other supervisors, parenting time supervisors before that, were there not?
Many.
Initially, parenting time supervision was ordered because of allegations that the father was going to remove the children from the United States, correct?
Initially, yes.
Okay. And take them where?
I would not know. Mom alleged Israel.
To your knowledge, both of the parents were born in Israel, were they not?
Yes.
So when you go into that jury room and RT's there, what do you observe?
I observe Dad, Art, and I observe him sitting in a chair with his legs up on another chair with his head in between his legs.
And what was he doing?
Very theatrically crying.
And when this is a 10-year-old, is it not?
Yes.
And you claim your characterization is he was theatrical, correct?
Absolutely.
So what do you say to this child?
I say very firmly, sit up.
Anything else?
I say basically knock it off. What's going on? Why won't you have parenting time with your father? I say a lot of things to him in that room.
Okay. Now, are you wearing your judicial robe at that point or not?
I would think that I was wearing my robe at that point because I literally had just opened my back door. I hadn't even gotten into my chambers, and then I walked right in there. So I'm guessing I was wearing my robe.
Now, this 10-year-old child did tell you that he felt that his father had assaulted him previously, correct?
He did.
And you informed him that you already decided that the evidence wasn't sufficient for that allegation. Isn't that correct?
Something along those lines, since the supervisor had testified.
Okay, but I'm not asking you what the supervisor testified to. Judge, please answer my question.
Wow.
You told this 10-year-old that you had already determined that the evidence was insufficient for that allegation. Is that not correct?
Your Honor, once again, she's really not giving her the opportunity to complete her answer. And I think she should have that opportunity, despite the fact that I'm going to have the opportunity to develop this further.
You may respond.
Thank you. We had a hearing previously as to that issue where witnesses were allowed to be called, where I heard one witness. I didn't prevent anyone else from calling any other witnesses. The parties chose not to call a witness. At that point, there was insufficient evidence to support his claim. The parenting time supervisor, who was apparently a police officer, a retired police officer, testified and said it did not occur. So I informed the child that basically we have to move on from this. Let's move on.
So let me repeat my question. Now that you have explained all this, you told this 10-year-old child that you had already determined that there wasn't sufficient evidence for his allegation. Isn't that correct?
I don't know if it's that exact, but I wanted to move on from that. Like, we needed to move forward in a spirit of having parenting time. But yes, that was the gist of it.
Let me show you examiner's proposed exhibit 69. Sixth paragraph down that starts with Judge Gorcyca. See if that refreshes your recollection. That is your 28-day letter answer, isn't it?
Yes.
Move to admit.
No. Did you have a chance to read
Yes.
it? And please read it to yourself.
No, I've read it.
Does that refresh your recollection?
Yeah. I told you that was the gist of it.
So you see this child crying, you tell him you found that his allegation didn't have enough evidence. What else do you tell him?
I tell him I couldn't get to the bottom of why this child would not even look at his father, would push food away if his father touched it.
Your Honor, if I may ask the court's
That's
assistant.
question.
My questions are simple. There is a time and place for counsel will have a chance to do another direct. He reserved his cross. What else did you tell him? I'm not asking what was in her mind.
It's an open-ended question. What else you tell them can include a whole lot of information.
Okay, let me rephrase the question then. Did you also tell this child that you want him to talk to his father? Yes or no?
Yes.
Did you make this as an order or did you encourage him to do that?
I strongly encouraged it, but you didn't let me answer the initial question. I also said things to him. What else did your dad do? Because I couldn't get to what he was alleging that had happened in April. There was insufficient evidence to support his behavior. So I said, well, what else? What's the next thing your dad did that would prevent you from having anything to do with him? And he said, my dad didn't say happy birthday to me. And as soon as he said those words, his dad said, oh, honey, I did say happy birthday to you. And I specifically recall saying this. This is a good thing, RT. This means you want more attention from your father. You want your father in your life, because otherwise, why would he be upset that his dad says a happy birthday to him? And I said, your dad wants to give you that attention. Your dad wants to be in your life. RT, remind me when your birthday is. And he said, August 29th. Now, this was on June 24th, so almost a year earlier. That's the worst thing that his dad did to him, he told me, was his dad didn't say happy birthday to him a year earlier.
Okay. Now, were you trying to encourage this child to talk to his dad at that point?
Yes.
And your conversation with this child took how long approximately?
I would not be able to say.
Now, you've already testified that there was an incident, I believe you said in April?
Yes. Well, I don't know exactly the date, but we held a hearing in April about it.
Isn't it correct that there was in March, I believe March 23rd, Art Gallagher testified?
In April.
Okay.
Or I thought it was in April, actually. I could be wrong.
And that's when Mr. Gallagher testified as to an incident that occurred at Dad's condo, apartment, or house, correct?
Yes.
Are you also aware of the fact that there was a Department of Human Services report in this matter that was submitted to your court and made part of the file regarding an assault allegation or threat by all 3 children? Are you aware of that? Do you remember that?
For when are you referring?
In 2010, August 25th of 2010, there was an allegation that the father had made threats against the children at a playground or park and shoved the mother. Do you remember that?
I do remember.
I'm going to object. I'm not sure how that evidence is really relevant to what this function is with regard to this complaint.
Yeah, as I cautioned, we're not retrying the entire trial again, but go ahead. Counsel, your question is what?
My question is whether she's aware that there was an allegation of a threat by the father to the children and shoving of the mother in 2010 that DHS investigated.
I am aware of that from almost 5 years earlier.
Okay. Now, at some point in time, you left the room to write a script?
Yes.
And
but I had more
whom did you consult,
if
anyone, regarding writing up that script?
Mr. Bossary, Miss Middleditch, and I don't know if it was if Mr. Lancet had anything to do with it. I know for sure Mr. Bossary came into my chambers. Miss Middleditch, we called her, my staff called her on speakerphone, and the 3 of us had a conversation.
What was the purpose for that script?
It was to compel the children to have parenting time with their father.
And in fact, the mother did read that script, did she not?
For all 3 children, yes, she did read that.
And how is it that the 3rd child get to be inside that jury room?
His mother drove him to court, and then his mother brought him into the jury room. Someone brought him into the jury room.
But you had nothing to do with that part, correct? You didn't order that child to be brought into the jury room.
When I had that conversation, the phone conference with the lawyers in the case, that's what the lawyers agreed to do. So they all came into my jury room, and then when they were all there, I came in.
Did you hear the mother read the script?
Yes.
Do you leave at that point?
No.
What happens next?
Well, actually, I guess I do leave. I think I left. I wanted them to. I thought that was going to be enough, and quite frankly, I thought I would never see them that day. So that was supposed to be enough. That was supposed to work to get these 3 children to have regular parenting time with their father, because now their mother is saying it and using my stern words. Not words like, do you want to see your father? No, you're going to see your father. He wants to see you. I want you to see him. So she used the words that I and her attorney and Miss Middleditch agreed.
Okay.
So I thought that'd be it. And I would leave and I would never see them again.
At that point in time, Judge?
Yeah, like maybe a little bit after that, yes.
And where do you go?
Back to, I'm either in court or in my chambers.
And do you receive some information afterwards about what's going on?
Yes.
Who gives you that information?
That I don't recall. If it was Mr. Bossary, if it was Mr. Lancet, if it was Tracy Steeb, it wouldn't have been Art. It was someone involved with the case that said they're absolutely refusing.
Who's they?
All 3 children.
So what do you do?
I went back into the jury room. I had a discussion with Mr. Bossary, with Mom, with Dad, I thought with Bill, and I don't know if the kids were there, and I don't know where else the kids would be since all of the adults in their lives were right there, saying that's it, enough's enough, I'm appointing you lawyers.
And you did appoint attorneys, did you not?
And we'll have a contempt hearing, so their due process would be afforded, and if it was necessary, we'd go to a contempt hearing. It was never, ever the point to have a contempt hearing.
Your Honor, if I may, we can go on forever. My questions are so simple, and I understand.
Did you ask an open-ended questions, and you're eliciting open-ended responses?
My question is simple. Did you appoint attorneys?
Yes.
Who were the attorneys?
Jeffrey Schwartz for the oldest, Michael Dean for the middle, and Karen Cook for the youngest.
Following these hearings, you did, oh, by the way, at the outset of this hearing, you ordered additional deputies, did you not?
Well,
yes or no? Did you order additional deputies for your courtroom?
If someone's going, yes, because that's what the policy is. When you have anybody that might be going in, it also works as a deterrent when you see that, so that that behavior doesn't continue.
Now, you signed an order, or several orders, following these hearings, did you not?
Yes.
Let me show you what has been marked as examiner's proposed exhibit 45, 46, and 47. What did I provide you with?
The orders from that day.
And those orders specify no visitors except Omer, that would be dead, correct?
No.
I'm sorry, you do not see that language on the bottom?
Where?
Of 45?
It says, and his approved people, therapy is necessary, GAL Lancet is allowed to visit.
Okay. Certainly not mom, correct?
Unless dad approved it, but on that one. But on the other one, definitely not mom.
On 6/25, did you order these kids back before you? That would be on Thursday?
Did I order it? No.
How about 6/26, 2015? Did you order those children to be brought back before you?
No one asked me to do anything.
Okay, that's not the question. Did you, on your own motion, order these children back before you on 6/26?
No, not until July 10th did I do that.
Okay. On 7/6, that was the oldest child's birthday, was it not? Did you?
Yes.
You didn't bring them back for that, did you?
I did not.
Did you contact Children's Village at any time during the children's stay?
I have a mutual friend that works there. So
again,
would
Your
I
Honor,
ask
my
her how
question
they're
is
doing?
not open-ended. Did
No,
you call
no.
Children's Village during
did
the
not.
children's stay?
No, but I would ask the guardian how they were doing,
Okay.
who was going over there.
You did not call Children's Village, correct?
I did not. I would make inquiries from people that would have direct knowledge. Yes, so I was
And these people
always
are who?
concerned about these children. People that had any access to the kids. If I
Who
saw
would have access to the children?
their lawyers, if I saw a lawyer, I'd say, have you seen the kids? If I saw Bill Lancet, have you seen the kids? Dad's lawyer, anybody involved, my staff would hear, we would hear things. We just wanted the kids to say, I wanted those kids never wanted to walk into the courtroom. Not once to walk in the courtroom. Then when they walked out, I wanted them to change their mind. Then when they got to the elevator, I wanted them to change their mind. When they got
Did you follow them
downstairs-
to the elevator?
No, I did not follow them to the elevator.
Did you go to Children's Village?
No.
Did you talk to anybody at Children's Village to find out about the well-being of these children?
I did talk to Brittany Kelso about it before she testified.
And when you say testify, are you talking about July 10th?
I guess, yeah, when she put on the record how the kids were doing.
Okay, but that was July 10th, correct?
Yes.
I'm sorry.
Yes.
And where was it that you spoke to her, on the phone or in person?
Well, I spoke to her earlier, I think in person, the day before, to ask how they're doing, if she would be willing to come over.
Okay, that would be July 9th, correct?
Yes.
And then on July 10th, did you talk to her again, or did she just place things on the record?
I don't recall if I talked to her on July 10th
Okay.
before the hearing or not. I know she was in the courtroom for the whole hearing with her boss. I know the courtroom was packed with lots of people.
Did you order the father to see, or did you request the father to see those children every single day of their confinement?
I did not. That was up to his schedule and him and what was going on. Same as with the guardian ad litem. They could go every day, all day, according to Children's Village rules and regulations. That's not up to me.
But you knew the father was not in the country, didn't you?
No, he was there.
He was where?
He was in court.
No. Between June 24th and July 10th, you knew the father was out of the country.
No one told me that on June 24th. I did not know. I don't know his schedule. The kids were supposed to have parenting time with him. I don't know when it is every day.
Now, did you order a special diet to be observed by Children's Village for these kids?
I don't even know what you mean when you ask me that question.
Okay. You did know that these children were from Israel, did you not? Yes or no, ma'am?
These children...
The children's parents were from Israel.
You asked me if these children from Israel. I know that's very important to you.
Okay. Did you know that the parents were Jewish?
Yes, and what does that have to do with anything with what I'm going to order?
And did you know that both parents were born in the state of Israel?
Yes. Eventually I learned that. I don't know where parents are born. I don't care where parents are born. I don't care what their dietary restrictions are at all. I don't think how this could be relevant to the co-examiner is beyond me.
Well, seeing you're not on the bench, let me continue with my questions. Did you order any special dietary restrictions, or at least for Children's Village to inquire as to whether these children had any special diets?
It's the most ridiculous question I've ever heard.
Wait. I'm going to object on the basis of relevance. I don't know how this is relevant. Thank you.
Thank you.
Now, you said during the hearing on June 24th that you knew that at least NT was kind of religious, correct?
Yes.
Did you make any provisions for any kind of prayer needs for the children at Children's Village?
Okay.
Same objection.
Sustained.
Were you aware that at least one child refused to eat certain foods at Children's Village because it contained pork?
Your Honor, not only do I object, let's stop this. It's very clear that you made a ruling with regard to this line of questioning. Let's not continue it.
Sustained. I am solely focused on Judge Gorcyca's conduct as it relates to June 24th. And the objection is sustained. Proceed.
You held a hearing on July 10th, did you not?
Yes.
And the connection with the father was made by phone, wasn't it?
Yes.
And in fact, he indicated where he was, didn't he?
Yes.
Where was he?
Israel.
In your 28-day letter, you said that telling the children about the cameras being everywhere meant to instill confidence in them that nothing bad or improper was going to happen. Did you not say that?
I also said other things regarding that, yes. So if you could not take it out of context.
Your answer is yes?
Yes.
And also you said to encourage them to interact with their father, correct?
Yes.
Also in your 28-day answer, you said that both parents have previously expressed through their attorneys that they did not want their children detained. Is that not correct?
Yes. No one wanted the children detained.
In your 28-day answer, Judge Gorcyca, did you also state that you did not want the children to think they were going to Children's Village at the defendant father's request, so you had told the children that the father had objected, did you not?
Yes.
Now, also in your 28-day letter, You were asked, and I will hand you a letter again on page 37.
Exhibit 69.
Correct, Your Honor. Beginning on page 37. And going into page 38, paragraph 53. You were asked whether you had initially told the children that they would spend the rest of the summer at Oakland County Detention Facility, Children's Village, Mandy's Place, and that the matter will be reviewed in September of 2015, correct?
Did I say that?
That was the question, correct?
Yes.
And you indicated, you quoted a portion of the transcript, did you not?
Yes.
That wasn't a complete quote, was it?
Your number 53 was not a complete quote.
I'm sorry?
No, it wasn't.
So the part that you didn't mention was the part about, well, as you throw up your hands, here, I'll tell you what, let's just review this when you turn 18. You didn't mention that in your 28-day letter, did you?
Didn't we attach the transcript and the video? The video is the video. The transcript is the transcript. I said a lot of things on there, and I was very clear that they held the keys to their exit, that it was up to them, that I would have reviewed it right then. I would have reviewed it the next day.
Judge Gorcyca, in your 28-day letter, did you omit the portion where you tell LT, I will review this when you are 18?
Did I include it? Yeah, I did include it.
Where is it?
It's right in the top page, part of 38 under Exhibit C. I mean, it might be one day, it might be 3 years, it might be till you're 18. And we'll have a review hearing when your dad comes to me and says, oh my gosh, it's right there.
In the 28-day letter, Judge Gorcyca, you indicated that the circular motion that we all saw in the video did not mean that LT was crazy, correct?
Yes.
In fact,
I said I believed. I had no memory of doing
in your
that.
28-day letter, on page 30, you stated that the gesture, you denied the gesture made while you were speaking was intended to indicate or even imply that LT was crazy. And then you continue to state you believe that the hand motion was intended to indicate that defendant father should let the court know if LT had made any forward movement as a result of the therapy he would soon be receiving simulating the motion of a wheel moving forward. The video depicts many hand movements throughout the course of the hearing. Judge Gorcyca frequently speaks with her hands, correct? Did I quote that correctly?
You quoted that part. Are you going to read the next bit?
Did I quote that correctly?
Yes, you quoted that part of it correctly.
Okay. Your Honor, I would move for the admission of exhibits 45, 46, and 47. With respect to 45, that pertains to LT, the oldest child, the 13-year-old. 46.
What are they're the three contempt orders of June 24.
No, I thought they were already admitted.
Yeah.
We had okay.
Will be admitted.
And 46 is with respect to NT and RT, and 47 is with respect to all children, and in order for them to be psychologically evaluated.
$45, $46, $47 are admitted.
Judge Gorcyca, part of the judgment of divorce is that neither party portray the other party in a negative light to the children, is it not?
Yes.
And in fact, at one point in time, there was an issue about the mom talking about an incident, an abuse incident by the father. Isn't that correct?
No. You said one instance. There were many multitude of instances that mom was alleged to have said that in front of the children about their father, in front of therapists, in front of parenting time supervisors, in front of lawyers.
In March of 2015, perhaps in April of 2015, did you not tell Ms. Middleditch to add to her show cause the fact that mom discussed or mentioned in front of the children?
Did I tell her to, or I said, are you orally adding it to save the party's money from having to amend another show causes, so to save mom and dad money? Yes.
Okay. So you said are you, or did you say do it?
Whatever the transcript says, that's what I said. And Mr. Bossary was in agreement to save everyone money, not to,
right. And
to
it
do
was
it
to
one.
prevent the children from knowing what the allegations are and what's going on. Isn't it true?
What do you mean?
Well, the children should not know what the parents are alleging, what motions they're bringing, any of that, correct?
No, I don't even know what that question is. That was for Miss Middleditch had a multitude of reasons she was filing show causes against mother. That was going to be a new allegation that mom was talking about abuse in front of the children.
By the way, were you aware that that one of the children was assaulted while under your order in Children's Village? Yes or no?
Right.
Nothing further.
Reserve.
Please, Your Honor.
Thank you. Judge Gorcyca, you may step down. Again, and even under the sequestration order, you have to discuss your testimony with any of the other witnesses that may testify in this case. Thank you. All right, let's take 5 minutes. All right. We'll reconvene in 5. Thank you.